With only hours behind the 8-1 decision today by the U.S. Supreme Court saying police must usually get a warrant before they take a blood draw on drunken driving suspects, it's hard to forecast what it all means. But we had lawyers, especially on the side of criminal defense, ready to weigh in.
This is a huge case for DWI law.
Marsh Halberg and his team is looking at today's ruling as a window of opportunity to attack a law Minnesota has with only a few other states, which is that if you refuse chemical testing of blood, breath, or urine, you are charged with a crime that can be more harmful than a first-time basic DWI. Halberg's stance is, if it's illegal now to get a blood draw without a warrant, how is it fair to penalize a Minnesotan for just saying no?
It's our position that all this refusal law that Minnesota has with only a couple other states is all unconstitutional. And there's a very strong argument for that.
It's a leap he says he will start arguing going forward. But not everyone agrees that it's a legitimate leap.
I think it's a non-consensual blood draw case, and there aren't that many non-consensual blood draw cases that I've prosecuted in over a decade of prosecuting cases.
Wren says most people consent to one of the chemical tests offered to them. So the idea that someone consenting is being denied a right, to him, is a non-starter. But that's not stopping at least one defense team that believes today's decision could change Minnesota law in the future.
This is by far and away the most fundamental and important ruling in DWI law since I've been practicing.